Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, I like to dive right in. First thing I want to talk to you about are the rapid change in USCIS forms. In some cases, only changing one or two, maybe three or four data points on the forms. So we've had some forms that were changed last week, and we weren't given a grace period of using the old forms before we were required to use the new forms. So the announcement came out, the new form was due that day. They wouldn't accept the old form. And that heavily impacted people that had filed the form the day before via FedEx for, next day delivery. Essentially, we had colleagues that were, scrambling and chasing FedEx to reroute packages back to them so that they could redo an entire application package. And if you know anything about immigration, it's usually several forms that are needed for one application. So some of my colleagues were chasing FedEx. Some of us were worried about applications being rejected by the Immigration Service, and it doesn't, when your application is rejected for, let's say, like lack of proper fee or lack of using the right form, it doesn't get sent back to you right away. Sometimes it can take weeks to get that application sent back, and in that weeks, and in that time frame, your application seems like it's in a black hole. We have no correspondence from the Immigration Service, so we don't know until it gets returned to us in the mail. And some of my colleagues and I were worried about clients being out of status as a result of this. So it was a bit of whiplash all last week about these forms. But we have some really amazing litigators who are immigration attorneys and litigators. So they filed a lawsuit in federal court, and the next day, we have our usual grace period by which we can use the old forms before the new forms take effect. So thankfully to our immigration litigators, we now have that grace period. So, the whiplash on this particular issue seems to be over. We'll see what happens with the next set of form changes. But I wanted to let you guys know that has certainly been happening this past week. The next topic, I've gotten a few calls, not a ton, but I definitely have gotten a few calls about an announcement that our president made, sort of kind of a haphazard announcement, if you will, not anything super concrete, about creating a sort of a gold card that would allow non-U.S. citizens to invest $5 million in the U.S., giving them, sort of this immediate path to green card, and getting rid of the current EB-5 green card path process. And so my crystal ball is, of course, a little bit hazy these days, but this would be it would have to be more than an executive order to get rid of the EB-5 program and really institute a new program of this magnitude. This really would require some sort of legislative action. So I bring it up really to say, I don't know that we're going to see this come to fruition. I'll keep you updated, but that's kind of all I really have on this, is that a lot has to happen in order to, one, get rid of the current EB-5 program, and two, start up a whole new investment program. So we'll see. I'll keep you updated. It was just kind of seemingly a throwaway comment. And so we'll see what happens. The next thing I've been getting a ton of calls about recently is, I have a green card, can I travel? And so a lot of times if you have a conversation with me offline, a lot of times, and sometimes when I go live, a lot of times what I say is, sometimes the issue is not can you, it's should you. So if you have a green card, you should not travel at this point. If you have an application to remove the conditions on your green card, that happens when you were granted a 2-year green card based on, a marriage application, and you apply to remove those conditions, and for whatever reason, that application was denied. So I tell people to think of that as converting from sort of a temporary permanent residence to a true permanent residence when you get a 10-year card. If your 10-year card application was denied, or your removal of conditions application was denied, the Immigration Service can then send your file over to the immigration court, which would put you into deportation proceedings. You're not going to get immediate notice. Like they're not going to send over one day and then day 2 you'll have notice that your case has been sent over to the immigration court. It usually takes a little bit of time, but in that time you don't know that that's what's happening. So if you are in that situation and you are a current green card holder, you're re-entering the U.S. If CBP has that information in their system, if it has hit their system, the systems that they're pinging upon your re-entering the U.S., you could be placed into, you could be held by CBP. We would then call ICE. If you have a current notice to appear, even though you're a green card holder, the notice to appear, or NTA, is the document that sort of begins your whole deportation proceedings process. If you have an NTA and you're a green card holder, I do not recommend that you travel upon re-entry. If CBP has access to that, again, you can be held. They can call ICE. You can then be detained. And if you have an old deportation order, even though you have a green card, you may still have an old deportation order. Again, not something that you want CBP to discover when you are in the U.S., when you are trying to re-enter the U.S. Using your green card. So if you fall in one of those 3 categories, technically, can you travel? Yes, you can buy a ticket, you can get on a plane, you can attempt to come back in. But the short answer is, should you travel under those 3 circumstances? No, I would not recommend that you travel right now. If that is something that you want to talk more about, I would absolutely recommend that you speak to an immigration lawyer about that. So in the can you travel and should you travel, sort of yes on both, is if you're a green card holder, you've had 0 criminal issues since obtaining your green card, you do not have a notice to appear, you do not have a denied application to remove the conditions, you don't have an old deportation order. So if you are just plain Jane, there is 0 going on in your immigration history or in your current immigration life, then you really shouldn't have any problems re-entering the U.S. on your green card. So I've gotten quite a few questions on that recently, understandably so. There's a lot going on in the media about that. So wanted to bring that to your attention. Now, it would not be a Monday morning if I did not talk about H-1B season. H-1B cap registration is here. It is live. It went live on Friday at noon, Friday the 7th, March at noon. So it is live. You can enter your registration as of right now. It ends March 24th at noon Eastern Standard Time. Please do not wait until 11:30 on March 24th. There are always little glitches when it comes to the lottery. Always, always, always. I've not seen a single lottery system right now with USCIS since they've started this that has gone through without any technological glitches. Like we know what's going to happen, and we just kind of have to plan to work around them. But please don't wait until 11:30 on March 24th. Because the lottery does close at noon Eastern Standard Time. So the fee this year, they've increased the fee. It is $215, up from like 10 or 11 all the other years. And so the other thing I really want you all to think about when it comes to the H-1B lottery is think about your plan B. Whether you're the employee or the employer, think about your plan B. If you are the employee and you don't get selected, what's your plan B to the H-1B? Are you going back to school? Do you have a spouse that is in the U.S. Who maybe is also in, maybe a different non-immigrant status? Can you become a dependent to their principal status? Are you eligible for another non-immigrant status? Are you eligible for TN, maybe an H-1B1, an E-2, an O-1? Are you eligible for another non-immigrant status? And sometimes, and nobody ever wants to hear this, but sometimes your plan B may be to go home, to leave the US and go home. So definitely want to figure out what your plan B is. And you may have more than one plan B, and that would be great if you do. But you may want to figure out your plan B now so that you're not caught off guard if you don't get selected in the lottery. If you are the employer, what is your plan B if you cannot switch this person or get this person onto an H-1B? If they're already working for you and they're in OPT, are they eligible for STEM OPT? Again, are they eligible for another non-immigrant status that maybe you hadn't thought of? Maybe you've never even heard of it. It's worth a conversation. And also, as the employer, you also need to understand that maybe their best option, if they don't make it into the H-1B lottery, or maybe their only option is to go home. So again, while we tend to focus a lot on getting people entered into the H-1B lottery and the registration process and setting up your organizational account and making sure that you have your password and doing everything correctly, you also want to make sure that you're really thinking about what's the plan B. And the reality is the numbers are that the majority of people that enter into the H-1B lottery will not get selected. So I'm not saying don't be optimistic. I'm not saying don't have a positive attitude about it all, but I'm saying be all of those things, but also be very practical, and consider what your plan B will be if you need it. And that's a conversation that, we have with our clients. We're certainly happy to help you sort of navigate a plan B. The next thing I want to talk to y'all about is social media. And I talked to my clients about this as well. So the Department of State on one of their DS forms, right, specifically asks for your social media handles. The Immigration Service, the Department of State, who, as we know, runs the consulates, will look at all publicly available information. That includes your social media platforms. Like if you are out there and you are all about social media and you are posting your whole life, don't think that the Immigration Service is not going to find it. Don't think that they're not going to, one, look for it, and two, find it. So there is currently a USCIS draft rule out there, or proposed rule, I should say, basically giving them, basically telling us that they're going to affirmatively start asking for your social media handles so that they can then go out and look at what you're posting on social media. Public comments are certainly available. You can certainly write your own public comments and send them in. Those would be due May 5th of this year. But y'all, if you want to be on social media, fine, do you, but understand that if you are saying one thing on social media and doing one thing on social media, but yet saying a completely different thing in your immigration applications, the Immigration Service, Department of State, the consulates, they're going to find it. And they can use that as a basis to issue you a request for further evidence, a notice of intent to deny, or to deny your application. So we often hear, be careful what you post on social media for all sorts of various reasons. So on top of all of those reasons that you've heard and that you may not like, or that you may like, or that you may agree with or not agree with, that's fine. Add immigration to that very long list. So just know that the U.S. Immigration Service, USCIS, is actively looking and telling you now that they have a rule out there. It's a proposed rule, and that they are going to they want to start affirmatively asking for social media handles. Essentially, it just makes it easier for them. Really, y'all, it just makes it easier. So just think about what you're posting on social media before you post it. And the last thing I want to talk about this morning is the EB4 category. That green card category has already reached its limit for this current fiscal year. So that annual limit will reset again October 1 of this year of 2025. But between now and September 30th, they will not be issuing any more green cards for EB4 category, so that fourth preference category. So you are in a holding pattern until the end of this current fiscal year, which is September 30th. And there's really nothing that we as outside lawyers can do to get them to process that. If they don't have the numbers, they don't have the numbers. So that again is on the EB4 category, has already reached its annual limit. So that is all I have for y'all this Monday morning. I am again Carol Williams with Williams Immigration with Beyond the Soundbite. If you have any questions about your immigration case, you want to talk to us about it, you want to figure out what to do, you want to figure out how to move forward, we're here to help you. So reach out to us. We'll get you a consultation scheduled and keep you moving in the right path. So again, have a wonderful